Number 128.
With regard to item number 8, Malam, we have played for a little bit of indulgence, Malam. I've filed an affidavit yesterday bringing on record the compliance order. Can that be called for me?
My lord, there is no compliance at all. I will file a detailed affidavit how they have made a joke of the court's order. I will file a.
Anyway, let it be called out. We'll see.
Yes.
Let it be called out.
Yes.
We'll see.
Yes.
Item number 9 to 19. Adjournment request.
May I please, Your Lordship, I beg to mention item number 13, Your Lordship.
All right. Studying adjournments. Take the dates first.
21-5.
Your Lordship, I beg to mention item number 14, Your Lordship.
Item number
14.
14.
14.
14.
14. 14.
The ghost filing case. Are you the advocate?
I'm the advocate. Because the brief is not with me. The brief, I'll be getting the brief on Sunday.
But you are the petitioner. Why should the
I
brief
am
not
the
be
petitioner, Your Lordship. I am the petitioner, but the brief is
You
not.
will be appearing in person.
I will be appearing.
Then you will not have to wear your band.
I will come without the band, no problem.
Why do you want adjournment?
Because the brief is with Nishant. Nishant is Delhi. He's engaged with his father's illness.
All right, you want adjournment?
Yes, Your Lordship.
All right. For what time?
I'll be getting the brief on Sunday. This Sunday, I'll be getting the brief. After that, it will be.
As prayed for by the petitioner in person, let this matter be listed on next Friday. Next Friday.
Your Lordship, let it be after 19.
On 20th of May.
Obliged, Your Lordship.
From item number 20 to 31.
Please, my lord. With the consent of petitioner, I beg to mention item number 22, my lord.
You have adjourned.
Yes.
Completed first. All right.
Obliged. Can it be on, my lord, 28th of May, my lord?
20th of May.
My lord, 20, my lord.
Is it okay? All right.
Obliged. Obliged.
From item number 32 to 37.
Please, Your Lordship. Lordship, with the consent of the parties, I'd like to mention item number 34, Your Lordship.
34.
Praying for the adjournment, Your Lordship.
You appeared for whom?
BDC, respondent BDC, Your Lordship.
Have you informed the other side?
Lordship, we have informed the
Has
respondent.
prayed on behalf of the respondent slash BTAC, no? BTAC.
BTC, Lordship.
BTC or BTAC?
BTC, Lordship.
Very good. BTC as a respondent slash BTC, the matter is adjourned to such.
8-6.
Obliged.
Prayed for and agreed to by the council.
Any other request?
Lordship, I beg to mention item number 40, Lordship.
40.
I've taken the consent.
Yes. Gary,
Yes, Your Lordship. There is some personal difficulty on part of Mr. Abir Fukan, Lordship. He is conducting the matter.
you are appearing for
For the appellant's, Lordship.
For the appellant.
For the rest.
As prayed for on behalf of the appellant and agreed to by the council for the respondent. The council for the respondent. The matter is adjourned. Give a date sometime in July.
Lordship, could it be any Friday,
No, it will go July. Why did you give consent then in hearing?
No, any Friday, date, maybe.
Any Friday.
Any Friday.
Okay.
Since-
Not this, not next Friday.
No.
17 July.
Kitna?
17 July.
17 July.
July.
Obliged. Keep your.
May I please? Lordship, I beg to mention item number 38, my lord, supplement. 38. In that case, my lord, we have filed a, my lord, additional affidavit for bringing on record the certified copy of the order.
38 has come under orders.
That leave application is there, my lord.
As prayed for on behalf of the
Next week, any day, my lord.
applicant appellate. Let this matter come up for consideration on next week. Next week,
Can it also to, I just filed a local number yesterday. I count of 5th of May, your lordship.
5th of May is too specific.
Yes, my lord.
After.
Keep it after 5th of
After
May, you
5th
can
of-
say that.
My lord,
Let it be
my lord, this-
15th of May.
My lord, matter was, this IA was filed for, my lord, without certified to be, some urgency is there, that is what. Some urgency is there, that is what.
15th of May, under the appropriate heading of admission.
Obliged.
Daily list for orders, item 1 and 2.
But make me your lordship. Mention. But.
Yes.
Lordship, may I pay for a listing of a matter on Monday, Lordship? Lordship have decided similar retribution yesterday, Lordship, regarding excluding the candidates of sixth schedule appearing in the interview, Lordship. Same document will cover, Lordship.
Item 1.
No, Lordship, mention. Listing, for listing, Lordship.
Listing on Monday.
Monday. Obliged.
Immediate, yeah, I get. I was familiar.
Huh?
Similar.
Same subject.
Same subject.
But then the order which we have dictated in court or the order which we stated, that will cover you.
Let's cover, Lordship. On the,
Anyway, we'll keep that.
Lordship.
April.
Yeah, this is an old matter who appears in item number 1 and 2.
I am equal.
Yes.
I have been recently engaged now.
I'm for the excise department.
What is it?
But I don't have to brief. Only my senior friend, Mr. Nath, gave me one IA, which indicates.
We have the parties list this matter on.
Lordship, in this case, my lord, we have filed.
Examine the file, examine the record. Something has been, some order has been passed in Supreme Court.
Lordship,
I think the matter is required to be rested. So you just find out and tell us.
Yes, madam.
We'll then close
I have
the
to reconstruct my file.
Mr. Forward, go to flag D.
My
As jointly prayed for list.
two affidavits we filed, my lord. One is on,
Don't give us such half-baked information. See, it's an old case. Tell us what is to be done.
two affidavits, additional affidavits we filed, my lord. One in 2019.
Anything after the Supreme Court judgment, flag B, please examine
Lordship,
and find out, and we are keeping it next week.
Lordship.
As jointly prayed for, list both the appeals under the same heading. On, give a date next week.
Order
Next Friday.
dated 1/12/2005, you go through and
Right.
take the.
30th April.
Obliged.
30th April. Item 3.
May be the law. In pursuant to last order, the paper publication has been done, my lord. Only thing that I got it yesterday, on 9th April, both of the papers have been done. I will bring it on record by next week, ma'am, to an affidavit. It has been published on 9th April in Sentinel and Procedural.
The paper publication with respect to notice to response number 6 and 7 has already been done. Mr. P.K. Roy Chaudhary, learned advocate for the petitioners, submits that necessary affidavit in that regard shall be filed in the registry by the next week. In that view, the matter, if that is done, let this matter come up for admission on your date sometimes in last of May.
22nd May. Item 4.
Well, here on behalf of the district commissioner, I have received some information, my lord.
One more date and then remind us, we'll take up the cut.
Service.
Awaiting the report on service.
My lord, the deputy commissioner who is named here, he is no longer here. From the present DC, my lord, I have got the information. He can implement, my lord, I am appearing for the present DC.
All right. All right. If it's appearing, yes, so let it, so this contempt case will be listed only under orders. Yes, what is your matter? Tell us.
Lordship, here kindly take up, give me 1 week time. Some instruction has come. I'm just awaiting.
As prayed for by Mr. Nath, United Senior Government Advocate for the respondent. Is this matter on? We have 2 weeks.
What's up, let's.
The name of Mr. S. Nath, Mr. D. Nath, be reflected in the cause list. That's for.
18th May. Item 5 and 6.
Well, in item 5 and 6, in 6, my lord, I'm trying to, my lord, set down copy, just affidavit I'm filing.
Spread for on behalf of the respondents. Let both the contempt cases be listed on next week. Without notice, you have evicted them.
No, I have
Anyway, file your response.
all the notices and orders I have annexed.
File
I'm
your
filing
response.
this. Yes, I'm filing it today.
Pablo, 30th May. 30th April. Item 7.
But I filed a fresh memo of parties after the impleachment was allowed. Well, the 9 to 13 were implemented as pro forma respondent. My learned friend appears on behalf of
9A, B, and C only, my lord.
the delay petition is before last.
You are appearing for,
9A, B, and C.
and who remain?
Other owners of land.
Other 10 to 13, I made them a pro forma respondent. In fact, 9 to 13 are there.
You received long back to them.
They have received notice.
Notice.
Notice they have received.
Only, what was remain is this 9-1.
Yes,
In
yes,
newly
yes,
So he is also appearing.
Yeah.
She is completing that.
yes.
With the appearance of Mr. So-and-so. Kya naam hai aapka?
D. Chakravarti.
Mr. D. Chakravarti for response number so-and-so. The service on all respondents is complete. Let this. What do you have to say? Would you file?
Regarding delay, my lord, I have no objection.
No objection, take the order for. The delay condone, the appeal to be processed and be listed preferably also.
Item 8.
Why did the compliance orders, my lord?
Yes, Mr.
My lord, they have not complied at all, my lord. It is a joke on the court's order, my lord. The lord's really very interesting that they have granted in, we are in higher secondary school teachers. They have pushed us to, my lord, primary school teachers. And not only that, this will, and the date of compliance is from 23/4.
Order.
Show us the order.
On order, just a copy there. I'll copy
Page.
there. I'll copy there. Let it be. Okay, the judgment, my lord. The judgment is, my lord, single bench judgment is, my lord.
The services of the petitioners as teachers and professors and fertilizer corporation be regularized, all consequential. Now, where is the order regularizing the services of the?
I just
Yes, I have
provided
given the copy, my lord.
just provided the compliance orders, man.
It was from the date of appointment.
Compliance of the fine of the services of foreign teachers have been regularized with effect from 1/8/2024. And is Pranjal Datta. All right, the order stands compliant.
No, it is not from one, however they have got the date 1/8/2024.
But
And my lord, see,
this regularization had to be, according to you, it had to be effective from which date?
from the date of appointment there, initial appointment.
Where is that direction in the?
You will also kindly, in the contempt petition, page number 21.
Read paragraph 24.
In view of the above discussion, the petition is allowed by directing the services commissioner, teachers in the very further corporation under has.
It has to be regularized from a particular date.
No, my lord, what is my submission is that the petition as it is.
That would be a further cause of challenge. We will not see it in contempt jurisdiction.
And also, my lord, will have to kindly see
We will give you that liberty. You file another petition, a separate petition in contempt jurisdiction. We are not going to discuss that.
Anyway, and my lord, see, even the pay scale given is the third grade.
Anyway,
Let it be, there will liberty will find.
issued by this court. By judgment dated.
Then they have not furnished the copy of the,
By judgment dated 23/4/2024 appears to have been complied with. The direction in the judgment was to regularize the services of the petitioners, writ petitioners as teachers in Brahmaputra Valley Fertilizer Corporation Higher Secondary School. And they be accorded all consequential benefits to which they would be entitled on such a regularization. The learned counsel for the respondent has placed before us an office order dated 21st of April 2026, intimating that in compliance of the order of this court, the petitioners have been regularized with effect from 1/8/2024. Though the learned counsel for the petitioner has some objection with the date from which the services have been
date and the grade. Grade
and
pay.
also the pay grade. But those are matters which would entail separate cause of action, which cannot be decided in the present contempt petition. So as such, the present contempt petition is consigned.
My lord, liberty may be given.
Haven't we said that? You don't need to couch particular words for a particular order. You said that that would be decided in a separate cause of action. That means you have the liberty. Mr. Sharma, you're a senior advocate. You
Yes,
know
I
that.
know that, but some,
Anyway, next.
there may be some confusion. Yes, in the compliance of there is confusion.
Item number 9.
Wait, please, Your Lordship. Lordship, the order of this honorable court, the relevant page is at page 65. Lordship.
Have you served a copy to Mr. Gogoi?
No, Lordship, this is against the respondent by name, Lordship.
Let notice be issued as a legal. The present contempt petition has been filed for non-compliance of the judgment passed by this court in so and so. Let notice be issued to respondents. The notice is accepted by Mr. S. Barua. No, you tell him. Notice is accepted by Mr. S. Barua, who shall communicate the fact to Mr. B. Gogoi, the learned additional advocate general, who would be required to respond to this application. Let the response affidavit be filed positively by the next date. We notify June 1st week.
Obliged, Lordship. Earlier.
5th of June, 5/6. Item 10.
So 6 weeks.
May I please, Lordship, my lord, the parties and private respondents are waiting the party.
Awaiting the report regarding service of notice on response number 1, 2, and 3. No.
4 and 5.
Number 4 and 5, the matters that here.
Public.
8 June. Item 11.
All right, what do you have to say? We are inclined to condone the delay. Your objection shall be noted. We delay the note. Please keep process, take it from him.
17th June. Okay.
And so deeply obliged.
For admission, item 12.
Yes, Mr. Manta.
My lord, my selection as a Gram Pradhan has been celebrated
How
petition.
many times do you want the court to disturb the selection of an Anganwadi worker?
No, this is not Anganwadi, Gram Pradhan. Earlier it was called Gaon Buddha, now it is called Gram Pradhan. So only 2 ground, my lord, petition was allowed. My selection was set aside. The first question is that, my lord, he has not, that petitioner is a family member, he's a family member of the RDR Gaon Buddha, my lord. So that's why he's entitled to get 10 marks. So that was given, my lord. In fact, that was given, but they have produced a final evaluation sheet. Individual marks given by the members are not placed before this court. That is first ground, it was allowed, my lord. And second ground, my lord, I am a member of a particular political party. I have not resigned. That is the resign from the party. But I
That's one
actually,
of the essential conditions. You should
yes,
be a member of a political
but
party.
I resigned, but it is true that, my lord, it is my fault at the time of hearing of the, my lord, petition, it was not produced, my lord. But subsequently, by way of a review petition, that was, my lord, placed.
That was not accepted by the
Not
court.
accepted, my lord. That is the 2 point, my lord. Only 2 point, my lord. But 10 mark was awarded. I have annexed them, my lord, that individual.
That in review the court has allowed. The court says that yes.
But so far is, my lord, yes, that is my fault that at the time of, my lord, hearing, it was not produced. It was,
It was not produced, but it is of a later date.
my lord.
Then
No, it was designed prior to, my lord, the advertisement, my lord. It was designed, my lord. That is accepted, my lord. But because, my lord,
the respondent number two has been working since when?
no, after, my lord, allowing this petition, my lord, he is working, my lord.
Buri. Yes.
My lord, the honorable single judge, my lord, considering.
Respond to the arguments that he has made.
Yes,
Forget about learned single judge. Respond to the arguments which he has made.
Yes.
He says that you have been marked for your being related to somebody, some village elder. That's right. So the review court found that statement to be correct. But because of the persistence of the objection with respect to his being a member of the political party, he says that the review court should have realized that this letter, non-production of this letter of resignation was a mistake and it was produced. He says that it was presumptuous of the learned single judge to have noted that this acceptance letter of his resignation from a political party was
Existed.
procured document after the whole election was over. He says it's of an anterior date. Where is the allegation? How did the judge come to know? That is his argument. How do you respond to it?
My lord, the facts and circumstances, my lord, in which, my lord, this, my lord, the resignation letter is produced before the honorable apex single judge, my lord. My lord, but the earlier, my lord, the earlier existence of this letter was
Working since how many years?
doubtful, my lord,
You're working since how many years?
20 years.
Oh,
My lord,
you were appointed on that post when? 2021.
no, my lord, after filing contempt, my lord, on 2003, 2024.
After the judgment.
After judgment and my lord,
After judgment and contempt.
contempt, my lord. My lord, and my lord, in this case, my lord, the writ appellant belongs to the political BJP ruling party, my lord. And also, my lord, he belongs to the Jalukbari constituency. My lord. Therefore, my lord, the doubt which has been, my lord, honorable India just. And my lord,
Manta, the difficulty is this.
My lord.
Now, you have some ground, but if I, for this grant pradhan every time for since 2021, the matter has been hanging fire. Where is the, I don't find any perversity in the judge.
No, my lord, your lordship kindly says so far, my lord, 10 marks is concerned.
See, how do we question the view of this single judge who says that, no, I don't believe it. The reason is that it should have been done. You supplied.
Yes, my that I admit
You
it, my lord,
supplied
yes.
the Mr. Mahanta, you have supplied the letter of your resignation from that post. But you have not supplied the letter of resignation from the party members.
My lord, correct. That is actually, that is correct, but at that point of time, it was, my lord,
We
it
go
was,
by the bigger law that unless the judgment of single judge is perverse, it should not be tinkered with.
Finding of fact.
no, my lord, actually it was missing, my lord, that's why not been, my lord, placed in the, my lord, affidavit.
Precisely for that reason, the review
It
petition
was dismissed, my lord. The review was dismissed because, my lord, order 41 rule 27, my lord, is not applicable in
very
the,
difficult for me to apply my mind to these petty disputes.
my lord.
Even my lord says,
Dismissed.
Deputy Officer.
Item 15 and 16.
My lord, 16 be taken up first, my lord. Or next, what are the? Second is the readable 46 be taken.
46.
My lord.
Yes.
But here is the case, my lord. The petitioner was appointed in the under compassionate ground in the district council area of Tarbiang-Long, my lord. By following procedure, my lord. Thereafter, my lord, he has been given a salary of 1 month. Then, my lord, the concerned authority, timing again applies to the authority since is the sixth area, my lord, they can appoint grade 3 and grade 4. But seeking, my lord, approval for regulation of his salary, my lord, the order was not considered, my lord, and wrong interpretation has been made in the page 4.
When did you apply for
My lord, I have annexed, my lord. I have annexed the copy of the petition, my lord, page
how
43, my lord.
how has the idea gained ground that you filed the application after 5 years of the death of your father?
No, my lord, that is the wrong. My lord. And that, my lord, lordship will see, I have given 2 types of application.
The death was in the year
Page
2007.
44, my lord,
2007.
my lord.
But why do you say 4?
No, my lord, 44, I.
5/12/2007 is the death.
My lord,
Now, there appears to be some mistake because the application appears to have been forwarded to the additional registrar of cooperative societies,
my lord,
to the registrar of the cooperative societies Assam on 17/11/2009. The
nine.
application would not have been made in the year 2013 as it was noted. But even otherwise,
My lord,
for whatever fault, you know the law, since you could not, even if it is fault of the respondents, the death occurred in 2007. Somehow the other, unfortunately, you could not get appointment. Now, how do you expect this?
my lord, I was already been given appointment.
That's all right. You were given appointment after 5-6 years and for a month, and then the matter went to the state level committee.
My lord,
Perhaps you were under the impression in the autonomous council, there is no need for that, but that's a mistaken motion.
no, my lord, there is an order of the
Where did you,
comment, my lord. Lordship kindly see page
Mr.
57.
Bhuya, where did you make your application? Before the learned single judge, where did you make a mention? Where did you make an averment that the state level committee was wrong in recording that the application was first made in the year 2013? That is after 5 years, more than 5 years after the death of the employee. You appear to have given an application earlier,
My lord,
as it appears from the records.
my lord.
But then where is that verment in the writ petition? Because that is the basis for the learned single judge deciding the matter and going back to the judgment of Devashri. Can I?
Page 28, paragraph 3, my lord. May I read, my lord?
Page 28 of your memo of appeal.
Yes, my lord.
Will not do, no?
My lord, that is
You have
the,
to show from the writ records that you made that statement.
yes, it is
It's
the
a long
copy of the
recording
writ
of fact.
petition, my lord. From
Page 28.
page 28 of the part, page 3, paragraph 3 of the writ petition, my lord. After the death of so and so, my lord, entire family become so no source of income as a result of.
They are asking for the date on which you applied. जो पूछते हैं वो बताइए.
Yes,
Mr.
my lord.
Borguya.
2012,
Otherwise also, we are not inclined to entertain this petition at this stage, especially when the death had taken place sometimes in 2007.
my lord.
In fact, the first appointment itself was doubtful. Without the SLC having approved of it, appointment letter should not have gone to you.
My lord, for that,
See, if sympathy were the consideration, we would have allowed your application. But
Lordship,
Supreme Court
kindly-
says that don't exercise sympathy.
Lordship,
elsewhere.
kindly have a look page 57 for a moment, my. It is their letter, my lord. Last paragraph, my lord. In the instant case, the case of the compassionate ground appointment in the.
The brief ends at page 56.
57, my lord. Annexure 10 of the writ petition. Writ petition, civil law.
Only 56.
The petition ends at page 56. Perhaps your numbering is wrong. You're referring to the judgment of the learned single judge.
No, my lord, it's a copy of the annexure which I have filed with the
You're referring to which document?
document, my lord,
The
ordered
writ petition, writ records or the LPA? Memo of appeal.
from the memo of appeal, my lord, I'm reading
Annexure 10.
annexure 10.
This is not in the retable 46. This is in retable 55. You are asking us to go through this brief and you are arguing from other brief.
Oh, my lord. Sorry, my lord, number.
Sorry, it's all right.
The sir.
7.
A letter dated, my lord, 8 March 22. Last paragraph, it reveals, my lord, since the autonomous council is the 6th schedule area, is empowered to appoint grade 3 and grade 4 posts. This was referred to the state level committee effort concerning coming persons.
We don't understand this framing of sentence. Since autonomous council in the 6th schedule area is empowered to appoint grade 3 and grade 4 post, this was not referred to the state level committee. Whether it was correct or not correct.
But in that case, my lord, they have not filed any affidavit, my lord, before the honorable Singh.
Yes, Mr. Shuche.
Let's look into page 65.
Please formulate your argument, then ask us to come to page 65.
Page 65 is that, my lord, that is the government notification providing the scheme for compassionate appointment on compassionate ground. The scheme in 2015 stipulates that it is required to be referred to the state level committee, though the power of appointment is vested with the autonomous council in respect of grade 3 and grade 4 post, my lord. Page 65, my lord, last line, my lord. First paragraph 8. What is the provision of the provisions for 6th schedule area? That is in the paragraph 8. In the 6th schedule areas, the following orders of the High Court dated March 2012, Bodoland so and so. The District and Territorial Council will constitute its own district level committee, excluding the Deputy Commissioner and Superintendent of Police, but with the competent officer of equivalent rank under control of the councils. The district level committee will examine each of the proposal in the light of conditions laid down in this OM and the parameters laid down in the Honorable High Court in WPC number so and so. And after thorough examination,
I forgot to ask you this question. Why these two appeals by the same person against the same?
My lord,
One appeal is, my lord, against the order of the Honorable Single Judge, my lord, regarding, my lord, my dismissal of the writ petition. Another writ petition I filed, my lord, because sometime in the month of April, my lord, I have been restrained to attend the office. That's why I filed two writ petitions. During the pendence of the writ petition, they have restrained me to come to the office.
You could have made that prayer by through interlocutory application in the same writ petition. It should not have been entertained. Otherwise,
After filing the writ petition, my lord, they have stopped me to come.
So you could have brought this fact on record by an IA. You can't file two petitions like this
But
against
I
the
have
same
already
order.
filed, my lord.
Anyway. Two different orders. But then that is only consequential order. Yes. The district committee will examine each of the proposals in the light of the conditions laid down in OM and the parameters laid down in OM High Court.
after consideration, the council will send the proposal to the state level committee.
Concerning department
My lord.
for consideration. So there is no.
Next slide. After consideration, the council will send the proposal to the state level committee for approval. So it was sent to the approval and the state level committee rejected it.
Same was also resubmitted at page 61, my lord.
But why this wrong date has been mentioned? That the first time the application was made in the year 2013.
13, my lord, from the Yumpin order that have been, maybe, my lord.
The state level committee decided it on only on the ground that the application in the first
My lord.
instance was delayed.
After
Which
my
is not a fact.
My lord.
What do you say about that?
My lord, that is a finding in the single judge also in the judgment of the single judge finding is also on the basis of the documents that the within 2 years petitioner has not submitted any document application.
If suppose the finding is based on an incorrect fact,
Yes.
there is no finding, no? Now, have you disputed this fact? That the first application, or have you affirmed this fact specifically, that the first application was filed only in 2013 and not before that?
My lord,
Because it appears that
the document which was annexed, which is annexed in the writ petition, it reveals from that documents that the documents which he has furnished is not the correct. On that basis, the single judge finding is there.
how is that possible, Mr. Shukia? Try and see the records of this case. Now, we are not otherwise inclined to interfere, but these facts have to be straightened, no? Everything was done in 2009. District level committee decided it. Instead of referring the matter consideration and instead of referring the matter for approval before the state level committee, they decided to appoint him.
My lord.
So this was much before, no? This was in 2009 only.
My lord.
So therefore, it cannot be said that the application for the first time was filed in 2013. You don't require a lot of mathematical genius to understand this, no?
My lord.
Well, where have you said, from where the state level committee has gone on this? And how has the London single judge decided about this?
That is, my lord, in the other writ appeal, my lord, page 57, it is there. The state level committee's findings.
No, Mr. Shutia, we understand that is state level committee's finding.
My lord.
But facts is not correct. We from the record it seems that it was not a fact that you had application was made only on 2013.
We are not getting very persuaded to interfere,
My lord.
but that is only because the fact that the death happened in 2007.
My lord.
But see, the facts are incorrect. The fact on which the state level committee decided the issue is incorrect, and single judge endorses that.
My lord, we have not filed the affidavit, my lord.
You don't file affidavit there.
My lord, in that,
Yeah, very difficult.
my lord,
And you give him appointment and then you withdraw it from him.
my lord, we have not withdrawn it, my lord. We have, the appointment order is kept in abeyance, my lord. Finance department raised the objection that without approval of the SLC, the finance department
Follow that.
My lord.
He's disputing that situation.
and the matter,
But the decision of the SLC is only on the ground of late filing of the application.
my lord,
Aren't you? How many times we are going to say this?
my lord. My lord, as we have not filed the affidavit, my lord, in that,
How do you justify this? Then how do we justify the order passed by the learned single judge? That's the only difficulty.
My lord, on the basis of the documents annexed in the petition, the single
It's
judge.
the document which says that it
My
is
lord,
filed into.
my lord, my lord, my lord. This
Show us,
specific,
Mr. Borbuya, show the document that you first made an
My
application.
lord,
and
my
you
lord.
found the file.
my lord.
Yes, my lord, annex,
And which unit?
my lord, page 43 is my application.
43 of which grade?
Of read petition 55.
No.
No.
Of petition.
55 that I have been submitted in 2007.
Let both the matters be listed along with the written records.
The single court page 43.
My lord, 43 is the application and date is the next page, my lord, which was forwarded. And page 45 is the second reminder.
No, where is the day?
Date, my lord. Page 44, my lord. Signature of the
It's only month and government employees are date. Signature of the permanent.
21/12, my lord. I made a statement, my lord, in my
Statement. There are two different kinds of statements here. Now, how did you get to know that this application for the first time was filed into us?
Page 44, my lord, date of signature is my lord 2012.
My lord, lordship will, that will confirm page 45, next page, my lord. Second reminder, I have written, my lord, that sir, my father so-and-so died, so the employee under additional register such a depot in the district of Kanviang and inspector died on so-and-so. That's due to the premature death on 3.
Where is the date?
Page 44, my lord, if your lordship look into page 44, date is my lord 2012.
21/12 month.
It is not 2012. This is only the month. which is 21/12. So no year has been given.
My lord, and it was forwarded, my lord.
2009.
In 2009, it was forwarded, my lord.
Page 58.
Page 48, my lord. Page 48, it was forwarded 2009.
You bring on record. This appeal will take it. Your original application.
Originally, it is with the government, my lord. Record may be called for. It is with the department, my lord. I cannot have access.
Mr. Shutia, you please bring the record.
My lord,
SLC.
And that has already been forwarded to the state level committee, my lord. State
Bring the
government,
records from SLC.
my lord, government advocate, my lord, state level committee. It is all the documents of state level.
Take it. The appellant is agreed.
Judgment will be declared in WBC 4046. 24/9/2020. Permission we are please telling. It
Both the appeals have been taken up together. Both the appeals have been heard together. We have heard Mr. J. Borbuya, learned advocate for the appellant, and Mr. J. Shooter, learned standing counsel, KAAC. The father of the appellant, from a senior inspector / auditor, under the additional registrar of cooperative societies, bracket Hills, Karbi Anglong, Diphu Assam, died in harness on 5/12/2007, leaving behind a large family, including the appellant. The case of the appellant is that he applied for compassionate appointment immediately after the death, which was processed by the district level committee. And on his being found fit, he was given provisional appointment on the post of lower division assistant, which is a grade 3 post in the year 2021. He joined the post on 29/1/2021 and had been performing his duties satisfactorily. Even the police verification was done in the same year. However, later, when the records were referred to the state level committee, the state level committee in its meeting on 2/3/2023 rejected the recommendation of the district level committee, citing that the application for grant of compassionate appointment was made on 23/5/2013. That is beyond 5 years of the death of the employee, which was in breach of the rules provided in the government OM of 2015, where the time limit for compassionate appointment has been set out. The state level committee, it appears from the records, was aware of the fact that the appointment letter had already been issued to the appellant and that provisional salary payments also were made. But because of the rejection of the recommendation of the district level committee,
State level.
Rejection of the recommendation by the state level committee, the salary to the petitioner was also stopped. No salary could have been released to him without the finance bracket SIU bracket close approval. The one of the writ appeals has been preferred against the judgment of the learned single judge, upholding the decision of the state level committee, and the other whereby the order passed by the committee restraining the order passed by the respondents in restraining the appellant from discharging his duty, which too was upheld by the legislature. A perusal of the records indicate that the appellant was given appointment in the year 2021. Which in itself appears to be questionable because of the long delay after the death of the employee. It could be for the fault of the respondents. Nonetheless, the sense of immediacy had already been lost. Sense of immediacy had already been lost. However, what has been argued today is that the state level committee, under the impression that the application for compassionate appointment was for the first time filed in the year 2013, comma, the recommendations of the district level committee could not have been accepted. So this fact prima facie appears to be incorrect. The recommendations by the district level committee was made sometimes in the year 2019, sometimes in the year 2018. The records, whether the petitioner would be entitled, whether the appellant would be entitled for national appointment or not, shall be decided. Shall be decided on the issue whether the appointment shall be decided on considerations whether the offer of appointment would be only to provide succor to the family in distress immediately on the death of the breadwinner. But nonetheless, for straightening the records, it would be necessary for us to ascertain as to the date and the year when such an application for grant of compassionate appointment was made by the appellant. Ms. Sumitra Sharma, what is your designation?
Government advocate.
Government advocate, who appears for the state level committee, shall bring the records of the state level committee with respect to the appellant on the next stage. Re-notify on also. If you did not file any affidavit, just bring the records.
One more thing, my lord,
We are not inclined, Mr. Borgway. Whatever may be the case, but because the order concerns a wrong statement of fact in a single judge's order, let us straighten it out. That's all. But
No, my
then,
lord, I'm not saying
the
that.
reason that for whatever
Lordship has dictated, my lord, district level committee meeting was held in 2014, man. Lordship said 2019. It is, my lord, page 49, district level committee meeting was held on.
I don't remember to have said the date of meeting. I remember to have said the date of your first appointment in 2021. Mr. Borgway, be very careful.
Lordship.
We are very careful about.
Lordship.
And since appointment was given to you in 2021, I mean, against a death of 2007, that itself is questionable today.
It is, my lord, by the negligence.
And even otherwise,
Lordship.
see,
I have received 1 month salary also, my lord.
you're not understanding what we are talking.
Yes, sir, Lord.
We have called for the records only to straighten the facts.
Lordship.
Otherwise, we are not inclined to entertain your application because the first appointment itself was suspect. The memorandum of 2015 says that the district level committee shall make a recommendation, send it to the department. Department will take a call and then refer the matter for final confirmation to the state level committee. Just a minute. The department, instead of referring it to the state level committee, immediately offered you appointment. So that was not approved. SIU approval is not there. Who will pay you? The officer is not going to pay you from his pocket. So I think you don't have a case. But then because a learned single judge has recorded all that fact, we must straighten it out. That's all.
My lord, notification is 15 and minutes is 14.
In any case,
Lordship.
if the death is of 2007, we have to be very, very cautious in accepting any such argument.
Wrong date has been quoted by the state level.
Even otherwise, even if the right date is there, तो आपका case कोई improve नहीं कर रहा है. Your case is not improving because initial appointment itself is bad. Number one, for the delay, and number two, for the reason that it did not have the SIU approval.
My lord.
Which you wrongly said in the not wrongly said, erroneously understood as not required in KAAC. It is the requirement under the OM of 2015 that it has to have the approval of the state level committee. All these things we'll say, but we will first record the facts.
Last.
2nd June. Item 17.
May it please allow.
This is item number 17.
Yes, my lord. My lord, the learned single judge did not interfere with the claim, my lord, solely on the ground that is a disputed questions of fact. My lord,
Mr. Chaudhary, was he wrong in saying that?
my lord, can I place one judgment of this?
That's right.
The
but
Gunanta court's case, my lord.
was he patently wrong in saying that?
Yes.
226.
No, my lord, at least the learned single judge should have, I mean, insisted upon an affidavit from the other side, because it is not a case of such a nature.
Correct. To that extent, you're right.
Yes.
Let them file an affidavit here.
Yes. Let us see, my lord, what is the disputed question. Because end of the day, my lord, you have taken some work from me. Now you cannot relegate me to civil court for your inaction. All that I am praying for is, my lord, you should prepare the bill.
It's one of the views which is very prevalent in many of the courts.
Yes.
That you go to civil court, get your money back. That is the view, I tell you.
No, my lord,
Because normally-
but there is exception, but there is an exception
But
to
there
that.
is no admission. That is the difficulty.
My lord.
There is no admission.
No,
there.
no,
They
there is no
still-
denial either.
No, they say
Yes,
that you have-
lordship
you have
is
not
correct, there is
completed.
no admission, but there is no denial either.
You need to respond, can I?
Yes.
Mr. Goswami, you need to respond.
Yes, Lordship.
For the reason that it's a second inquiry report.
Yes.
What prompted it, number one? Number two, did you ask him to complete the work if it was incomplete?
Yes.
No, if these two things are not there, then it refers that deliberately you don't want to pay.
Yes, Lordship.
Why? Because he has not offered you any cut.
I will respond, Lordship.
I mean, this is not this may not be a fact, but this can be argued, this can be presumed.
Lordship.
And we don't go by presumption, but then you must tell him, no? Where is the statement that you asked him to finish the leftover work? And where have you blacklisted him?
There is a report of conclusion.
Take it. The appellant participated in the tender process for a government construction contract and was able to back the contract for construction of veterinary sub-center at Sonapur in Kachar district. The work order was issued to him sometimes in the year 2020 for an amount of approximately 30.64 lakhs, which according to the records was lower than the estimated cost. The site for construction was also handed over to the appellant. And according to him, the work was completed on 15/3/2021, which fact was officially communicated to the respondents. However, as it appears from the records, there were complaints against the appellant regarding slow progress of work and substandard construction. So because of such complaints, an inspection was held by PWD officials in the year 2021 and 2022. And the inspecting team, according to the appellants, gave a satisfaction report that the work had been completed according to the approved design. Over and above the said report, another high-level inquiry committee was constituted in late 2022, which actually submitted a report which was very divergent, which was different from the original report by the PWD officials. The high-level inquiry committee found that the work was incomplete and required rectifications. Though the appellant contended that the second inquiry was without any notice to him, and the same was conducted behind his back. But the real grievance of the appellant is that no payments have been released to him despite having completed the work. Mr. Ken Chaudhary, Leonard Senior Advocate for the appellant, submits that when the matter was brought to the notice of the Leonard Single Judge, he refused to entertain the petition on the ground of disputed question of fact regarding completion of the work. Completion of the contract work. Which, according to the appellant, only amounted to which view, according to the appellant, only amounted to skirting the SAIR, skirting the main issue. The contention on behalf of the appellant that nothing has been brought on record to indicate as to the necessity of constituting another inquiry committee and conducting an inquiry behind the back of the appellant. Just of that apart, if the work was incomplete, specifications would have been, it would have been specified as to which part of the work is incomplete for the report of the high-level committee to be acceptable. And if such report were true, the appellant could have been asked to make a rectification. First of not doing so and withholding the payments to the appellant is a matter which ought not to have been, it has been argued, relegated to other forum like civil courts for recovery of the due amount. Let a detailed affidavit on behalf of the respondents be filed by the next day, indicating as to the stage of construction of the building in question and whether the appellant was asked to rectify or complete the construction. Re-notify on so and so day. You can't avoid making payments. I mean, you have to treat, that you're a mighty organization, colossus. But you can't treat like this. So you say, finish off this work, then we'll pay you. Yes. Where have you said so? This is no disputed question of fact. You'll dispute it by saying, dispute comes when he says that I have completed, you say, porch you have not completed. Garage you have not completed. Then it becomes disputed. You can't make a vague statement now. Can you, Mr. Goswami?
If 4 June.
July. Otherwise, you'll have to pay extra charges, interest also. और जितना काम किया उतना का पैसा क्यों नहीं दिया?
I will reply.
जितना काम किया उतना का पैसा क्यों नहीं दिया? Where is the second report which says that that it is earlier report is bad? Number one. Number two, the substandard, subpar construction materials have been used. Where is it? And where is the report? Let's see the report.
I will.
Bring that report, no? Otherwise, it becomes, it gives an impression that because you are state, you will not do anything. कोई काम करेगा नहीं आपके साथ. And had it been a big contractor, you'd have to pay.
When it comes to big
30 लाख
contractor,
रुपए
my
का
lord,
इसलिए तो आपको जल्दी
then even escalations are also forthcoming.
anyway, yes.
17 July.
Show us good reasons that because he is a petty contractor. 30 lakhs का क्या काम होता है आज के दिन? It's a simple kind of a 2-room building. क्यों नहीं complete कराएंगे उससे? Had it been for some bigger company, we would not have been so particular. Yes.
17 July. Item 18.
Wait, okay. The method become infectious hospital.
It has become infructuous.
Yes.
What happened?
It was actually, it was pertaining to market settlement and the settlement was up to 31st March 2026.
June itself over.
So, actually 31st March 2021.
Mr. R. Sharma, learned advocate for the appellant, submits that this appeal has become infructuous. He therefore wishes to withdraw this lien. Dismissed as having become infructuous.
Item 19.
Yes, Mr. Chairman.
My lord, petitioner is my lord, physically handicapped and he is of having a hearing impairment. But he was initially appointed on the ground that if he could not fail or if he could not pass in the provisional test, then he will be given upon alternative arrangement. Subsequently, he could not pass my lord, provisional test. Because he was put in on the normal candidate, so naturally he failed. That fairly admit he failed, my lord. Thereafter, he applied for alternative arrangement. As per appointment letter, kindly have a look to page 49, madam. Page 49.
No, we didn't follow the last sentence.
49.
What
So,
did you say? Last sentence, what did you say?
yes. Alternative post, my lord. Subject to his
The
ability.
respondents say that that kind of stipulation in the appointment order was wrong.
No, they say they have discontinued. It is their statement, not wrong, my lord. They say they discontinued, my lord. And wrongly given. After 9 years, my lord, a person, your worship.
Only for the reason of his being 40% handicapped, we are issuing notice.
Only, my lord, because he is still in quarter, my lord. And wife is family, so that is not my lord in the family. I lift your worship, my lord, but I think it is some.
Many times. Huh? Where is the council?
Council, my lord, it is central admission tribunal.
Deputy.
Railway department. Railway department.
We'll come back after 2 minutes. In the meantime, you send in a word to Mr. Chaudhary.
Madam.
Either he comes or somebody else on his behalf.
Madam.
Then we issue notice just like that.
Then we'll supply, my lord, we'll serve the notice, my lord. Oh, yes, ma'am.
Okay. You represent whom?
I represent the Union of India. Railway. Railway or not? Railway lordship, we represent railway also lordship. No, item 19. Just a little bit.
The petition, we have heard Mr. Chaudhary. Mr. H.R. We have heard Mr. H.R. Chaudhary, learned senior advocate for the petitioner. And Mr.
DJ Das, your lordship.
DJ Das.
DJ Das.
DJ Das, learned advocate for the Union/Railway. The present application is against the order dated 20th of April 2026, passed by the Central Administrative Tribunal, hereinafter referred to as Tribunal, Gauhati bench, Gauhati, whereby the tribunal has refused to interfere with the termination of the petitioner from the service on account of his having failed in the proficiency twice. The case of the petitioner is that he hails from SC community and has 40% hearing impairment. He was provisionally appointed as a stenographer grade 3 in Northeast Frontier Railways under a special 2012 recruitment drive for persons with disabilities. His appointment was conditional on his passing a stenography proficiency test of 80 words per minute within 2 years. He failed twice in such proficiency test, once in the year 2019 and the other in 2020, which prompted the employer to give him a termination notice. The contention of Mr. Chaudhary on behalf of the petitioner is that at the time of his appointment, it was stipulated that in case he failed to pass the proficiency test, he would be accommodated in other kind of job. However, for the reason of his having failed in the proficiency / skill test, his services were terminated, without taking into account that he was put to a test without any handicaps, even though he had a hearing impairment of 40%. The contention of the respondent employer / railways is that the process of accommodating persons who fail the proficiency test in other trade / posting has been discontinued. The petitioner therefore has questioned the correctness of the order terminating him from service, as also the order passed by the tribunal upholding such termination. Mr. D.J. Das, learned advocate representing the respondents, shall put in his written response to this memo of appeal, to this petition by the next date, re-notify 4 weeks.
Only, my lord,
No, stay.
only quarter, my lord, one day might have children are.
ये केवल sympathy के ground पर है, बहुत
Yes,
मुश्किल है.
that might have.
Let certificate come, you will be asked to vacate the quarters, but we can't help it. कोई justification होनी चाहिए ना हमारे पास.
So,
Judicial order की only because Mr. H.R. Chaudhary was.
no, my lord, I'm just, my lord, because he's having.
Please dismiss the petition had he
No,
not.
my lord, I'm obliged to your lordship. I'm obliged to your
Had he
lordship.
been suffering from hearing impairment. And this whole appointment, you have to answer that. The whole appointment was under a special recruitment drive for people with disabilities.
Yes, ma'am.
So therefore, how can you discontinue this? How can you discontinue this? Let them file their response.
Only short date might have subject to if they make us, if possible. Ma'am.
3 weeks. We'll be asking you, Mr. Das, this question.
regarding the discontinuation of the policy also. Obliged to.
All right. Your date. Before that, we must have your affidavit. Then we'll question the very, you could not have discontinued it because it was a special recruitment, right?
Yes.
पर आप तो स्टेनोग्राफर ग्रेड थी, सुनेंगे ही नहीं तो कैसे लिखेंगे?
मैं सुनेंगे मतलब 40-60%.
80 words per minute is not a big thing.
That is there, madam, but that put me along with some normal candidates.
Item 20.
May I please, Your Lordship?
Just a minute. You can challenge that order before the DRAT. They will not ask you to deposit money. You were there in that case, no? Where we have held that no money is required for, no mandatory pre-deposit would be required. But look at this. We are not inclined to interfere for the reason that the registrar did over-exceed his jurisdiction. No difficulties. But then the tribunal also, on that ground of your hard copy having been filed much after, but then you have been dispossessed from your property.
Lordship,
Have you been dispossessed from the secured property?
Yes.
Then what do we do?
No.
We are not going to put you back there.
No. Leaving aside my PC application to be disposed of marriage, I have a case, Lordship. I have a very good case for.
But once you are in the system, why don't you file a petition before the DRAT?
No, Lordship, there is no appeal rights against in the DRAT.
Against this?
Yes, that is why I'm before your Lordship.
Under Rule 5.5, you're
Yes,
right. You're
yes.
right there. Yes, you respond.
There is no provision for appeal because it is not an under
Correct.
application under
Correct.
section 17.
Sorry, we missed out on that, Mr. Nandi.
Yeah.
You're right. We have heard Mr. K.K. Nandi, learned advocate for the petitioners, and Mr.
M. Sharma, Your
M. Sharma for response
1,
number
2, and 3.
for response number 1 to 3.
And 4 is Union of India.
The petitioners are the guarantors of the borrower who had taken credit facilities from the ICICI Bank. A SARFAESI proceeding was initiated against the borrower when the loan went bad. A sale notice also was issued with respect to the secured property. The petitioners challenged the action of the Greater Bank under Section 17 of the SARFAESI Act before the DRT, Gauhati, sometimes in the month of May 2025. The petition was filed through the e-filing system and requisite / prescribed fee also was paid. However, as it appears from the record, the hard copy of the application could not be filed within 7 days as required under Rule 4(2) of the DRT and DRAT Electronic Filing Rules of 2020. There appears to have been some miscommunication between the earlier counsel engaged in the matter and the petitioner. However, in the meanwhile, the bank proceeded further and the petitioners stood dispossessed from the secured property. So it was only later in point of time that the petitioner could learn about the hard copy not having been filed. Immediately thereafter, the hard copy was filed. However, the SARFAESI application was rejected in the first instance by the registrar himself on account of delayed filing of the hard copy of the application under Section 17 of the SARFAESI Act 2012. Such action of the registrar of the tribunal was questioned before the presiding officer of the tribunal, who, though was of the view that the registrar ought not to have rejected the application without further reference to the bench, but did not interfere with the rejection of the application on the ground of non-compliance of Rule 4(2), namely filing of hard copy of the application under Section 17 within stipulated time. The contention of the petitioner is that the actual date of filing is the date of e-filing and not the submission of the hard copy, and that the filing rules are directory, which cannot be invoked for the purposes of rendering an applicant remediless.
Further, Rule 4(2) is not in existence now.
Remediless. There is no provision against any order passed by the presiding officer under Rule 5, subclause 5. Hence the present petition. Mr. Sharma, learned advocate for the respondent, shall reply to this petition by the next day. Re-notify. We are just asking for your reply. Otherwise, we'll ask the DRT to dispose of his application.
Rule 4(2) is not in existence, Lordship, now.
Let's see. Let him respond.
Hey, after amendment, it is not in existence.
4(2) is not, but
Yes.
after amendment. Not now, but that time when it.
That time also it was not. In 2025, it is amended.
So you respond. I say 4(2). 4(2) जहाँ पे लिखा है उसमें लिखा है which provision now stands deleted from the
15(6). Item 21.
May I please refresh? My lord, this PIL has been filed, my lord. For my lord, flood affected an erosion area of Barpeta, my lord, using bulldozers. And certain parameters have been laid down. None of them have been followed and they are utilizing, my lord, bulldozers. If your lordship permit me, my lord, I can give the photocopies, my lord. They are using.
Just a minute. Mr. Gogoi, you are appearing for response.
Forest Department.
Response number 2. Who appears for response number 328?
I am for, my lords, 2, 3, 7 and 8. There's a private respondent. Only one private.
Who appears for 4, 5, and 6?
I'm paying for 4 and 5. Then it comes to board and.
Well, there's a slight issue here, my lords.
6.
6.
We don't know response number 1 here. Yes, what's an issue?
Issue, my lord, the certain similar kind of petitions, my lord, assailing the same settlement, my lord. There are repetition, 2 repetitions are pending, my lord. Same issues, sir. But I'm not,
We are not issuing notice to respond number 9.
my lord. Yeah, my
This,
lord.
this remains with you. You have to tell us.
My lord.
Take up. The present writ petition has been filed. Lagging the menace of illegal and excessive sand mining activities in Becky River. Has been brought to the notice of this court that because of such uncontrolled mining, particularly without any proper safeguard, severe riverbank erosion has occurred, posing a direct threat to nearby residential areas, markets, schools, and agricultural lands as well. Even the homes constructed near the river are at the risk of collapse, which could endanger lives and livelihood as well. The river Becky, flows in the state of Assam through Bhutan and crosses through ecologically sensitive zones such as Manas National Park. Because of degradation of the river ecosystem as a result of indiscriminate sand extraction, positive harm is being caused to the environment, including lowering of riverbed, destabilization of banks, groundwater disruption, increased flood risk, and damage to biodiversity. The learned counsel for the petitioner responded that the mining contract was backed by respondent number 9. Who appears to have obtained necessary environment clearance only mechanically. There has been no field verification or assessment of environmental or human safety impacts. Though environmental clearance was given to respondent number 9, but the necessary prerequisites and duties of the contractor of maintaining safety zones, protecting the hydrogeological regime, and adopting safeguards are not being followed. Dam-like structure has been created on the riverbed. And heavy extraction machinery is being used, which further causes erosion. The representations of the petitioners before
Public representation.
state environment impact assessment authorities has yielded no result. Hence the present position. The learned advocates indeed D. Gogoi accepts notice on behalf of response number 2, 7, and 8. Any problem, Mr. Parua? Accepts notice on behalf of response number 3 and 4. And Ms. Sumit, response 2, 3, 7, and 8 ऊपर में लिखा है. Mr. Parua for response number 4 and 5. And Ms. Sumitra Sharma for response number 6. Necessary response affidavit shall be filed by the next day. Only thereafter shall this bench consider the desirability of issuing notice to respondent 9. As against him, there are other writ petitions pending before different benches. We notify July.
Notice may be issued on interim prayer also, madam. Otherwise, my lord, very purpose of filing.
Let us see.
Get July 20. Item 23.
My lord, in this three matter, my lord, I prefer some time to my lord file up to the
23, 24, 25.
25. So far 23 is
Money
concerned.
has to, rental has to be paid.
My lord, so far 23 is.
You are exploiting them.
My lord, so far some technical difficulties.
Mr. Manta,
My lord.
we expect greater, cooperation from you.
My lord,
Because you're-
I am ready, my lord. I am ready.
Because you're appearing for the High Court. Now you have to tell us which all officers were residing in this place,
That I have to find it out.
whether they have got their HRA and whether they have paid their part or not.
My lord,
And that you will give us
My
in sealed cover. Within 2 weeks. Well, this is a serious matter.
yes, ma'am. No, so far is 23.
And we will not be asking the state now.
So, but 23 is concerned, no problem, my lord. Last month, my lord, some.
No, we don't want to hear anything.
My lord, sorry.
You just tell us
Fine.
whether they have accepted HRA and after accepting HRA, they have not paid.
My lord, I understand. That's why, my lord, I take some time, my lord. I.
Give us in an envelope.
Fine.
Then we'll take action. It's not done. You represent High Court, therefore we are asking.
My lord.
It's only thereafter that I will, at the instance of Mr. T.J. Mohanta, learned senior advocate appearing for the High Court. All the 3 matters are adjourned to. I'm giving you only 4 weeks.
My lord.
Please furnish
Definitely, my lord.
details to us. They should not be left unpaid. not even for a day. This is no way of dealing with people. I mean, I'm not telling you, I'm telling,
I understand.
I'm telling you, the
Yesterday
persons
only I
who have
came to
done
know,
the thing,
madam.
I mean, it is meant for somebody else, my own officers,
Exactly, madam.
my own officers.
Yes.
Just inform us.
Madam.
We'll pass a judicial order, and if necessary, we will also take administrative action. Unfortunately. You have to be very specific. The rental, the house was let out to which officer? For how many months? Why it was not paid? Administrative statement. Tell the registrar general that he's the आज में कल हमारे पास ये तीनों के रिपोर्ट 23, 24 जी please call the registrar. Yeah. Yeah. For a minute. What is the normal process? Deputy Commissioner pays the So it's online. Online.
I plead the lordship, my lord, I have not received the instruction. I need some time, more time, my lord. I'm appealing for the health department, my lord.
So DP Bora, Learned Standing Council submits that he has received necessary instructions for filing a counter affidavit.
No, I have not received.
He has not yet received.
Not received.
Why?
My lord,
When did you send for the information?
my lord, I sent him. I have received a letter, my lord. I sent it on 24th, 2026, my lord.
Again. Mr. Bora, Mr. DP Bora, Learned Standing Council, Health and Family Welfare Department submits that he shall shortly be in receipt of necessary information for filing a detailed counter affidavit in the matter. He therefore seeks a short adjournment. Re-notify this case on after 4 weeks. In the meantime, you receive instructions, file your affidavit.
Yes, madam.
It's about geriatric care.
Yes.
All of us someday or the other will need it.
Yes, madam.
Correct.
Actually, it
The
is under
issue, the
process.
issue has very rightly been flagged by him.
Actually,
There have been 3 deaths in my knowledge after I came here, where it was only because of a wrong injection having been administered. Correct.
Yes, madam.
And you can't even blame the person
Yes.
because she was hardly educated, the nurse.
The matter is actually under process, madam.
15 June.
Public, madam.
Item 27.
May it please your lordship.
Yes.
On last occasion, lordship notice has been issued and the department has to file counter affidavit, your lordship.
Counter affidavit has not been filed.
Lordship, I am appearing for respondent number 2 and 3, Lordship. Instruction is awaited, Lordship. Some time may be given for.
What's your name, Madam Counsel?
MS N Chaudhary.
Huh?
MS N Chaudhary.
Ms. N. Chaudhary, learned advocate representing respondents number 2 and 3, seek some more time to put in their response to this public interest litigation. Let requisite affidavit be filed positively by the next day, 6 weeks.
Obliged, Lordship.
28 July.
It's that Gorkha certificate thing, no?
Yes,
Lordship.
Lordship.
Please. Item 28.
Yes.
Well,
Yes, Mr. Raj.
Ghostly service was made without an pursuant to lordship's order. The order lordship went 4/2/2026.
Respond number 2, has he been served?
Yes, yes, my lord, we have paid, my lord.
What do you have to say? Whereas everything we have noted in our order.
Yes, my lord.
You need to respond?
No, we'll go by the record, my lord.
Huh?
We'll go by the record, my lord.
You will not file a petition.
No.
Then we'll not permit you.
My
We
lord,
will not permit you to file any additional evidence.
no evidence is necessary, my lord, in this case. No evidence.
Are you ready?
Yes, my lord, I'm ready.
And you will not find any affidavit here,
Yes,
as you are
yes.
saying about
No, here we will not file any affidavit, my lord. We'll go by the record, my lord. This is appeal, my lord. Everything is on record, my lord.
you will not respond to the.
Actually, my lord, it's a-
It shows your lack of experience.
my lord,
You have
Sir.
not read our order.
yes, my lord, I have
Your
seen, my lord.
management will charge you. Your management will charge you. We are not supposed to advise you.
My lord,
The
Sir.
entire petition has been decided on 4/2/2026.
yes, my lord, yes, your question of law is involved, my lord, in this case, my lord. So I think, no affidavit.
Price for the employer. Then we will allow the petition. Then we'll allow the petition, we'll set aside the judgment of the learned
No,
single
no,
judge.
my lord, that may not be.
What? The law we have written. What kind of overconfidence are you having? What kind of overconfidence are you having?
I have got the law, my lord.
You have got the law.
Yes.
And what did we write in our judgment? No law.
My lord, I have so, my lord, what is the law, my lord, in this?
What
in
is
this
the
case,
law?
my lord?
Show us.
Yes, my lord. They have come only, my lord.
We know the facts.
Yes.
Since we have dictated the entire judgment, the entire order, we know the facts. You tell us the law.
Yes, my lord.
Now the learned single judge relied on a concurring opinion
Yes, yes.
of one of the judges, which was a side swipe. It was only a parenthetical statement that cannot be treated as the ratio, binding ratio.
Well,
This is what we have said. You say that we will tell you the law. We are aware of Lakshmi Devamma.
well, I am relying only one judgment, my lord, in this case, my lord. And also rely,
Over and above the Constitution bench judgment.
they are also, their judgment also, they have, what they have relayed, but they also favor our case, my lord.
Yes, sir.
जब आपको समझ ही नहीं आती है बात तो क्या
I am relying one judgment, my lord. Procedural can listen. Paragraph 61, my lord. Paragraph 61 of the judgment, my lord. Subparagraph 1, my lord. 61, my lord. Last paragraph, my lord. Last part.
Yes.
61, subparagraph 1, my lord. If no domestic inquiry had been held by the management, or if the management makes it clear that it doesn't rely upon any domestic inquiry that may have been held by it, it is entitled to straightway adduce evidence before the tribunal justifying action. The tribunal is bound to consider the evidence so adduced before it on merits and give a decision thereon. In such a case, it is not necessary for the tribunal to consider the validity of the domestic inquiry, as the employer himself does not rely on it. And in this case, my lord, there is no domestic inquiry. And we'll straightway go to the adduce our evidence on merit, my lord. It is not necessary to file an application for allowing us to adduce evidence, my lord. By this paragraph, my lord, lordship will kindly see the tribunal has to consider our evidence, my lord.
क्या नाम है आपका?
Age ahead.
Hmm?
Age ahead, my lord.
When you argue before a division bench, before the Chief Justice's court, you must be doubly sure when the court is asking you. You are referring to a division bench judgment of 1972.
Yes, my lord.
The law has been laid down in 2001 by a constitutional bench judgment, deciding all laws. And then an interpretation was given on section 11, subclause 5.
In all the case, subsequent cases.
That is, it was, I mean, the maximum concession which could have been given to you as a counsel, because we don't want to take you by surprise. Can you cite this decision? Can you cite this decision which has long been impliedly overruled?
My lord, lordship kindly see. In all these subsequent cases, my lord, they have referred in this case, my lord, all this was discussed, my lord. This case was discussed, my lord.
So what have they said? So which will
accept it? Accept it.
So this case was considered, and ultimately an interpretation
This
was
was relied,
on
my lord.
11.5. Can you refer this judgment?
This has been referred, my lord, in all these cases, my lord. This is the basic principle has been laid down in this case.
But no, you're unnecessarily irritating the bench. We will accept your argument, but we'll have to say that you're not understanding the basics. We can accept your argument. We will not ask you to do anything. But aren't you understanding what you're talking? What kind of lawyer you are? If a judgment is taken care of, it is considered in a full bench judgment, which decides the law. Do you say that it has been followed? I mean, I know that this must be lack of experience. You are not trying to offend us. You are not trying to irritate us. But this is completely, this naivety, I'm surprised. And you're not even understanding what the court is hinting at. This is professionally incorrect, Mr. Counsel. When you quote a judgment over and above which there has been a gloss put by a constitutional bench judgment, and when later another bench of the same strength says that because this judgment, full bench judgment, has always been applied with great, no fault can be found with that because it appears to be fair. You can argue on a different plane. Can you say this? Many a times in different jurisdictions, let me tell you, if this kind of judgment is cited and it is insisted upon by the council, the matter goes to bar council because this amounts to misleading the court.
Not misleading.
You're not understanding, Mr. Mr. Zahid. Try and understand. Ask your colleagues.
Well, then we should file in favor. We may file.
Whether you file or you don't file, that is your lookout. But can you cite a judgment over and above this? Aren't we aware of this? When we talk about Lakshmi Devamma, don't we know that Delhi Cloth General Mills and Ludbut Singh was considered? Jitendra Jha was considered. We are not angry on your submission. We are angry on we get surprised at the way in which you are addressing this court, knowing fully well the court is making you understand this is not the law today. When we are making you understand this, why can't you? You say that whatever judgment your lordships have to pass, it can be passed. But if you don't understand like this, what is the purpose of all this court and advocates and others? There is a different argument which you can make. There is a different argument that you can make. We have raised a ground that the single judge went on the concurring opinion, one paragraph which was a side swipe. The ratio does not talk like this. Show me any judgment which says that the ratio of Lakshmi Devi Amma is bad, it needs interference. Show me any judgment. What? Your Ludbut ka dikhaiye. There is only one paragraph which is counter, which is therefore the matter had gone to the larger bench. Kuch na padhte hain, na samajhte hain. Anyway, please don't mind our exasperation. But because you're a lawyer, you look a young lawyer. Are you a regular practitioner of high court?
Yes.
Abhi nahi samjha aap. आपकी लेकिन ओवर कॉन्फिडेंस इज noteworthy. It is a matter of great enjoyment. Where आप गलत बोल रहे हैं, when the court is telling you you're not understanding, you're not even trying to rectify yourself. एक बार फिर पढ़ लीजिए and try and understand where you're going wrong.
Yes, ma'am.
Try and understand. This does not talk about your skill as an advocate. Have you ever found this bench getting angry on production of a judgment? But showing this judgment in the face of later judgment of a bigger strength of a bench, holding completely differently, aren't you misleading? I'm on a different, we will not be misled. Many advocates come and go. We don't get misled as far as we understand ourselves. But can you do this and you're still insisting? Today you leave this. Please apply your mind. Ask your junior also. Ask others. Go through the judgment. बहुत देखो ऐसा है कि this court is not very strict with the lawyers. But don't take advantage of it, especially when the court is telling you that this is a bad law, that you're wrong law that you're citing. You're still citing it. One of the charges against an advocate before the Bar Council in departmental proceeding was this, and a known advocate, VC Mishra, that a wrong decision was cited. You don't understand and you are insisting. I only wish you had said this before some of my colleagues in Patna. पढ़िए समझिए, it's every day we learn. Every day we learn. You can question that. You can defend the judgment of the learned single judgment. Don't show that judgment. He's not understanding, I'm sure.
You go through our order, the judgment we have relied on, and we have whatever discussion we have made, and compare your judgment, which one should be applied. Argue on that. Or if you have any other point, don't say that this paragraph covers your point.
सीखिए, I mean, इसमें कोई खराबी नहीं है. Don't feel that you have been vanquished or something. We are not speaking all this from the position of strength. We are only speaking it. I mean, we are letting you know because we consider ourselves to be parents patriae. नहीं तो इतना पर मैटर कहाँ रेफर हो जाए आप नहीं पता है. ये क्या insistence है? What is this rigidity? What is this rigidity? You can't even say sorry.
Yes, ma'am. I'm sorry, I will say.
You go through it. Go through it. Tell us if we are wrong.
Yes.
If we are wrong, we will say sorry to you.
Yes. No.
Chalo. But Sharma, who was the advocate who was appearing just before I rose for lunch? I'll just tell him that he should not feel demoralized or something. He has every right to ask. Huh?
It's the jacket.
Can you just send for a message? Because when I speak harshly to an advocate, it keeps haunting in my mind. Unless I tell him that no, I don't feel bad. It was just trying to make you understand. So just inform him.
I will.
All right. Yes.
29 to 31.
Yes, we can post for me. No, for me to go. But,
One second. Have we heard this matter before?
No, my lord, long back, your lordship's heard some, for some time, long back, my lord.
No, these
Last year.
sites matter. We had heard, we had passed some orders.
There is another matter, my lord, lordship wanted to have a drone footage of that
Yes, yes,
area.
yes.
That
It's
is a
not that
different,
case.
no, that's a different matter, my lord.
Two other
Here,
matters, one is Howley and one is Prakhar district.
yes, my lord. Yes, here we are concerned, lordship is just overseeing regarding the solid waste management.
Waste management rules and compliance. of it.
Exactly, my lord. Lordship's, my lord, two dates back, my lord, lordship passed an order pursuant to that they have filed an affidavit, additional affidavit, giving the details of the initiatives taken as well as what are the pending, my lord, projects in the subject, my lord. They have given a detail. I think, my lord, it was filed in the month of January. Regarding the pending projects, they'll have to give an update. What is the status of those projects? My lord, it's quite a. On 14/11, lordship has passed an order, 14/11/25. Lordship has directed us to indicate. And so for the number of waste management facilities, kindly come to order within 14/11/25.
Yes.
The learned government advocate shall obtain instruction as to number of waste management facilities that are required all over the state. The same would be inclusive of the waste management facilities that have already been constructed. Those are under construction. Those that are yet to be constructed. The council shall also obtain instruction as to the number of land sites identified by the state respondents on municipality control towns and places where the waste management.
That's right. So, status of detailed project reports.
Yes. Well,
We would be satisfied if you're doing something in that.
We have filed the affidavit. Kindly, on page 339, we have indicated what are the position.
339.
Relevant paragraph 4 at 339. 339 onward.
When did you file it?
We filed on 30th of January 2026.
It's not you.
239.
330.
Three pages is not there. It ends at,
Ends at something.
Lordship, kindly take up PIL 5th of 2016.
Okay.
3 cases are there, no? The 50 changes. 50. Kindly come to page 339, para 4. Look. At present, we have 101 municipal boards and 3 municipal corporations in Assam. Total population we have indicated, and the next page logic will find the waste processing capacities of the existing capacity of the urban local bodies.
is ELB.
Urban local bodies. We have also annexed a tabular formula at page 351. There we have stated present status of the
current status of the EPRs and all.
Malo.
Updated status you give and then we decide.
Malo.
Then we will close this.
Not to that. In other two, there is item this PIL 50. I got the records from the previous amicus, Milord, but I checked up, cross-checked, Milord. There is some deficiency in my records. I'll also, Milord, update my records, Milord. I'll reconstruct it. Some 10 days time, Lord, will kindly permit. I'll reconstruct and I'll place it.
We'll keep it sometimes in July.
Fine, madam.
They go to your
Fine.
funds.
Fine, madam. They'll also get some time
I think many of the projects will be completed.
By that time, not.
The last of the affidavits filed on behalf of the state lists the number of facilities for segregating solid waste and the ongoing projects for preventing any dumping of waste, thereby disturbing the city's civic life. An updated affidavit is required to be filed as to the status of those projects which are under construction. Let that affidavit be done by the next, let that affidavit be filed by the next day. Re-notify all the three.
17th.
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 Highly obliged.
5%. 28th July. Item 32.
Yes. Yes, sir.
May I please tell us? Lordship, now the matter has gone into deeper is that the bank has shown agreement copy, candidate copy, where they had mentioned it is a continuing guarantee is there.
Continuing guarantee is a concept which is not unknown in the banking world. We understand that. But once another document, another property was secured,
Yeah.
and I think that continuance of the guarantee is over.
As per section one
Unless you
thirty.
show us any law to the contrary. Look, we are observing in your favor, Mr.
Yeah, yes, I am.
We are observing in your favor. Yes, why don't you allow her to withdraw the money? See, NSC certificate, you have always, you have taken it.
Yes,
As part of that secured arrangement.
Yes, sir.
Now, this is a savings bank account.
Yes, sir. Section.
That no lien was put on that. So why will you give instructions? Which is the bank? You are the bank.
UCO
Bank. But why?
Your Lordship, section 171 of contract.
What is it?
We have in general lien, Your Lordship.
We have a general, you have a general lien. But you have to consider this, no? Now there is another guarantor, there is another secured
But
property.
he has not been released, Your Lordship. Until and unless he be released or discharged, he cannot be.
Very
And
good.
we have made him party before the DRT.
Make everybody who is related to the borrower, a guarantor.
Your Lordship, there are so many judgments.
Judgments are all right, but then you have to take a practical view of the matter, no? The entire amount is less than 2 lakhs. The outstanding dues is much greater, for which you have a secured property at other place.
Yes.
The only prayer is to allow her to access her savings bank account and take out 1,80,000 or something, if I'm not mistaken. That instructions you must take. Don't be a Shylock. Bank, all right, you need to claw back your money, but not this way. You can't let people starve, no? She will not starve. She is the wife of the borrower.
Yes.
We understand that. But it's a petty amount, which will not be even 1% of the dues. उसको निकालने में क्या परेशानी है? I don't appreciate this. I don't understand this rigid attitude of the bank. Take instructions and get back to us. The petitioner does not want anything else except access to a savings bank account. If it has huge amount, perhaps we'll have to look into it. But it's 1,85,000.
I don't take it.
इससे ज्यादा तो नहीं कुछ चाहिए.
But Your Lordship, they are also party in the DRT case also.
They may be.
Original application.
Take instructions and tell us.
Yes, sir.
Even the claim of the petitioner, it is appeal. The claim of the petitioner is that her position as a guarantor for her husband's loan was effectively substituted when a third party property was mortgaged. So that way, the owner of that property, the owner of the mortgaged property, has become the new guarantor for the loan. Despite this change, the petitioner is not allowed access to her savings bank account where less than rupees 2 lakhs is parked. So, Mr. M. Sharma. Mr. M. Sharma, an advocate for the UCO Bank, seeks some time to take instructions in the matter before addressing this court. We noted that the only relief prayed for in this petition is to allow the petitioner to withdraw the balance amount from her savings account, over which the bank only claims a general lien. And the amount parked in the savings account of the petitioner is of a lesser, is less than rupees 2 lakhs. We notify on 4 weeks they are given, take instructions.
Bless you. Thank you.
8 Item 33.
What has happened in Supreme Court? Second service pension.
Malot, our case of dismissed, Malot, in fact, it's covered by this judgment, that is 24/3/2026. Malot, the issue involved is that what are the mandatory qualifying service for earning the pension in the second service is 15 years. That can be condoned or not.
Read this.
I have provided that judgment, one copy.
Shortfall, there's not the issue with respect to shortfall.
Admittedly, in the instant case, the petitioner is less than 1 year of the mandatory service.
Mr. Tamildar,
Lordship.
have you read this judgment?
Yes, Lordship. I'm entitled.
We'll do it on some other day. I'll have to go through this judgment.
Malot.
Let this matter come up for consideration next week.
Malot.
Next week or next to next week? No, the second pension, I mean, has that issue been decided about?
Decided by the Supreme Court, so in view of that, by petition is Malot not, I am not going to get any benefit.
You don't press this petition.
Not by Malot, in view of this Supreme Court judgment, definitely I don't have any case, Malot.
In view of the judgment of the Supreme Court in civil appeal number so and so 2026 arising out of diary number so and so. Mr. Goswami, Mr. U.K. Goswami, Learned Council, Learned CGC does not press this petition.
But instead of saying that, Malot,
in view of the Mr. U.K. Goswami Learned CTC submits that in view of the recent judgment passed by the Honorable Supreme Court in civil appeal number so and so arising out of diary number so and so, which covers the case of the petitioners, there would be no necessity of pursuing this petition any further. We he therefore does not press this condition. Dismissed as not pressed. Like that.
Item 25.
Need pieces, my
My
lord.
lord, in this case, I'm appearing
Pursuant to-
respondent number one, my lord. I'm led by Ambassador Senior Counsel. My
My
lord,
lord,
Say he has some bereavement, my lord. He has just now left the court. Let him
Pursuant
come
to-
on Tuesday, my lord.
Allow him to speak first. Do you understand? You represent the constituency number 217.
23 to 17 months.
So what are you saying? I didn't hear. You was trying to.
I'm so sorry, ma'am.
My lord, 217 number is creation of the,
Correspond number one.
yes, my lord.
Who is your senior in this?
Ambassador. Today, yes.
There has been a bereavement in
Yes,
this.
my lord.
It's
I won't object, my lord, but my lord is, the affidavit pursuant to my lord's order had set the record straight, my lord. Doesn't matter now who appears, my lord, because my lord had put a very pertinent question that the state should say which number under which Anganwadi center the appointment was made. Now, the affidavit is very clear, my lord, and with the deepest respect, if I may say so, my lord, my learned friend, she's an imposter, my lord, for 5 years. She's serving in an Anganwadi center, which she's not a member, my lord.
all right.
Yes.
All right, but we will wait for Mr. Chaudhary.
My lord, my lord.
Yeah, a prayer for chairman has been made on behalf of respondent number one on the ground of there, on the ground of there being a bereavement in the family of Mr. Chaudhary, learned senior advocate, who has to address this court on behalf of this court. Let this matter come up for consideration after 2 weeks.
Next week. After,
19 May.
After 2 weeks, I'll fix the date. Deeply obliged. Wait, wait.
Take the date,
Yes, sir.
19 May.
9th of May, 19th of
Supplementary list, item 39.
May I please also? Lordship, page 130, paragraph 17.
What is the matter?
Lordship, this is the NCLT matter. I filed an application for raising the jurisdiction issue before the tribunal. Earlier, I approached this one, got this one, allow me to withdraw the petition with an observation that the NCLT will
No
decide.
order was passed on the issue of maintainability.
Yes, Lord. That's it. Till date, Lordship, and the tribunal is insisting my personal appearance before the tribunal. Lordship, may come to Lordship, page 130, paragraph 17. Page 130. So in the meantime, every month case is listing Lordship, but my application is not decided. My application for maintainability is not be decided by order dated 19th March. Personal appearance of my was order to be fixed on the by the tribunal. My prayer before Lordship may specific direction may be issued to the NCLT to first might decide my integrity application where I challenge the maintainability laws.
For passing that order also, we need to notice the bank, respond number 2.
Lordship, order was placed before the honorable tribunal, Lordship. Lordship, I'm not making any submission, but tribunal is taken objection against why we approach the honorable court.
Why?
Why we approach the honorable high court? That is the reason, Lordship. And Lordship, for instance, page 147,
Then we will not leave it to the, we will issue a direction.
Lordship,
That time it was a request, this time it will be a direction.
Lordship.
Let us see whether they do it or not.
And Lordship, my personal appearance may not be insisted by the tribunal. Lordship. Because Lordship, page 149,
Personal appearance of?
Lordship petitioner. Lordship. Page 149, paragraph 9. The learned comes before the PGA by directly.
resolution professional is has
Appointed.
started his work, so there
Yes.
is no adjudication.
Lordship,
It shall be decided.
this Lordship, we have no objection, but Lordship, my preliminary objection with regard to jurisdiction. Lordship, that is because my, as per section 60, the tribunal where the
Correct, we have noted that, but
No.
since it is not, I mean, let's say.
Lordship, no final education has been there, Lord. And every time my application is deferred, Lordship. And Lordship, I order dated 19 March. My personal appearance was given, Lordship.
That paper was on 17/4.
Yes, Lordship. 17.
What happened on 17?
17 Lordship, order of contempt proceeding is issued against the respondent. Asking to file, so-called notice has been issued, fixing 18/5. Lord.
No appeal, there's no provision for appeal before the NCA.
Because nothing has been educated, so we are refraining from filing appeal action.
What ground personal appearance?
Lordship, that is, Lordship, that is also not clear. Lordship, we come to page 49, paragraph 9.
Personal appearance, you can go, there is no difficulty. Once you go, if they insist for regular personal appearance,
No, Lordship, it was not.
they don't ask, I mean, the tribunal is not asking for regular personal appearance. One presence, I think, why should we stop it?
No, Lordship, we are, Lordship, not on that, Lordship. Now, my concern is, Lordship, to decide my application of jurisdiction issue, Lord.
Correct. So we will issue notice and then we pass it on.
Lordship,
Let notice be issued. To respond number,
respondent number 2, Lordship.
the correct procedure would be to have the registrar of the NCLT impleaded as a party and we notice the registrar and ask him why this has been done. But then this only undermines the dignity of a court.
Lordship, that is.
So that we don't, therefore we are restraining ourselves. Otherwise, we can always pass an order and since it is not harming you presently.
Lordship. Lordship, we are not.
Let the other side be here.
Lordship.
Let us not pass any order in the absence of the concerned party.
Lordship.
Was it? He will say nothing. He will say that this is correct. It has been done.
Yes.
Resolution professional is a, I mean, appointing a resolution professional does not mean any adjudication. It shall be decided. The request of the court has not been rejected.
Lordship.
The only difficulty is normally the procedure which is followed for such judicial bodies,
Lordship.
quasi-judicial or judicial bodies, is to notice the registrar.
Lordship, that we have not made party because.
वो करेंगे तो आपका केस खत्म हो जाएगा.
Lordship.
You want us to do that? We can do that, but you lose out on your case.
No, Lordship.
Let us call for the.
Respondent number 2, Lordship, Indian Bank Law.
Let notice be issued to respond number 2 on steps being taken by the petitioner within a period of 1 week, both modes, returnable on after 3 weeks. Let dusty notice also be served upon respond number 2 for its appearance, for his appearance in the matter on so and so.
Well,
All right, we'll see.
May I pray to Lordship for till returnable date, further proceeding may kindly. because next is fixed on 18th.
That would not be appropriate because this is no proceeding in the eyes of law. This is collating information. Otherwise, we would have done it. We would have also asked for dispensing with the personal presence, but it is for the first time that it is being asked.
Lord-
If consistently they keep on asking for your personal presence, we'll stop it.
Then Lordship, before 18 Lordship.
What happened on 17th for?
17th for Lordship, my advocate, he submitted that he is withdrawing from the case. So Learned Tribunal issued proceeding under section 435 Companies Act. And
Against?
under 453,
Against whom?
against the present petitioner. Lord. And asking him to give Sogo's reply why he was not appear on the 17th.
Your first appearance is a must. You must go.
No, Lordship, I'm not.
Go on the first day.
So Lordship, before 18th date may be fixed. Lord. 18/5 case 6 fixed in the tribunal.
Not before 18.
12th May.
No choice.
Sir, does the
Lordship, I'll.
Daily list for hearing item 36.
क्या है?
As per the direction of this honorable court, Lordship.
See, we are very careful in allowing even. No. The family members of the respondent may not pursue because it is to their advantage. And when the salary was directed to be released, despite all this forgery, then I think necessary consequences would follow with respect to post-death, dispersal of money. So we need to say that you have to take instruction and file an affidavit
I have already filed an affidavit, Lordship.
that you are not interested. And you shall not, there is no requirement of the appellant to pay any money now.
No, Lordship, we are not at all interested. That is my specific.
Then you withdraw. Then you withdraw the petition asset.
Page 250.
Are you understanding? Who is your senior? Yes, Mr. Talukdar, why don't you take over? You're troubling the lady.
No, Lordship,
Why are you troubling the lady? Then you withdraw this. We record his statement. Don't pay anything. Finish. Matter is over. Why are you taking so long to think about it? एक ही difficulty हो सकती थी. There could have been only one difficulty, that with the order of the single judge not being interfered with, perhaps you'd be required to make payments post-death to the heirs. But he says he is not interested. Finished.
Lordship, may kindly look at page number 251, Lordship, paragraph number 5. It's already on record.
It's all right.
Yes,
That is-
Mr. After this affidavit, what
That
remains?
is very wise of you. Because this would have revived many criminal cases against you. And not all cases await with the death. So it is very wise of the wife and sons of the respondent. Very wise. In fact, even the judicial order appears to have been fabricated. How many FIRs would it have led to? You never know. So therefore, you have taken a very correct stand. Somebody with good sense of justice has advised your client. I mean, it must be you. Yes, Mr. Talukdar.
may I pray that an order of closure instead of withdrawal in view of the affidavit? Lordship will close it, with appeal.
How does it make a difference? Why you people are so afraid of your clients? We will not say he is withdrawing just like that. We will say that in this view of the matter, the petition is closed, it is withdrawn.
Right.
Closing, there is no such terminology as closing a petition. Either you allow or dismiss or permit it to be withdrawn. Even for withdrawal, you say dismissed as withdrawn. Take on affidavit.
Checking actually.
No, we'll do something for both sides. So let us first give an introduction to the facts of the case, and then we close it with their affidavit. That would be better.
Correct.
We have heard Mr. Who appears for the appellant? You're not for the appellant, no? Mr. Dalgar, you're for the appellant. On the last date, Mr. B. Kaushik had appeared.
Yes, but that could enter depends today only. That is why I was.
Well, we are Department
Yeah.
of School Education. Ma'am.
Huh?
Appellant is Department of School Education.
We have heard Mr. S. K. Talukdar, learned advocate for the appellant state. And
A. Bhattacharya Lordship, Legal Aid Council Lordship.
Mr. A. Bhattacharya, Legal Aid Counsel for the family members, for the heirs of the respondent. The respondent was appointed as an honorary assistant teacher in Panitola Hindi LP School on May 27, 1977. Just days before, the school was provincialized on June 1, 1977. At the time of provincialization, the school's managing committee did not have the authority to appoint teachers. And under the Assam Elementary Education provincialization rules of 1977, only teachers with at least 2 years of continuous service prior to provincialization and their meeting qualification criteria could have been retained. The respondent, the writ petitioner, हमने क्या किया है? The writ petitioner, ना? हाँ? हमने रखा हुआ है भाई. They responded while he was alive. Sought regularization of his services. But during the course of the proceedings before the courts of law, it was discerned that many fake and forged documents were filed in support of the claim for regularization and securing salary. FIRs were lodged, and later there came the allegation of even the court order having been fabricated. Even the court order of dropping the case against the respondent having been fabricated. Despite such staggering facts, a single judge of this court, taking into account that the original regularization order passed in favor of the respondent while he was alive had not been cancelled or set aside, salary was required to be taken. This order of the 11th single judge was put to challenge, has been put to challenge by the appellant / state of Assam. During the pendency of the proceedings, the respondent / writ petitioner died. The next heirs of the late respondent, later employee / respondent, have filed an affidavit that that none of his family members have any interest in any financial implication or in any consequential benefit for which the respondent, while alive, had been fighting for. In that view of the matter, Mr. Talukdar, learned advocate, appearing for the state of Assam, submits that this case could be closed as having become infructuous. Dismissed as having become infructuous. Dismissed as infructuous. That's all right. There is no concession from.
Item 27.
Yeah.
Item number 31 also I'm asking for an adjournment.
क्या कर रहे हैं?
Asking for an adjournment.
You are asking for an adjournment.
Requesting for it.
No, that's all right. It's same thing.
No.
It could be a question. As prayed for on behalf of the appellant and agreed to by the counsel for the respondent. The matter is adjourned to July.
In July.
So where is Mr. Zahid? I had called him. Or